Kim Davis, a clerk out of Rowan County, Kentucky, and Memories Pizza of Walkerton, Illinois. Two local names, both thrust into the national dialogue over the same issue, same-sex marriage, and for the same reason. Serving gay couples as part of their job violates their religious beliefs. Now, religious freedom legislation and case law have historically been used to protect socially deviant individuals and groups from government persecution and to protect religious organizations from unnecessary infringement upon their basic practices. Now, the post Hobby Lobby usage, and I'm referring here to the Supreme Court case Burwell v. Hobby Lobby, changed this precedent to be protective of specific Christian views and corporate interests. This is controversial and was likely intended by the same Supreme Court that made the Hobby Lobby decision. All of this can be determined through an examination of the Supreme Court cases that led Congress to pass the Religious Freedom Restoration Act of 1993, the RFRA, and its aftermath, guided by the legal expertise of several constitutional law scholars and Supreme Court Judge Samuel Alito himself, in the language of the court's 2014 Hobby Lobby decision. I'd like to start by asking the question, what is religious freedom, and showing how that answer has been refined under both national and international law. Next, I'll look at the RFRA itself, the legal decisions that led to its passage, and that which led to the Hobby Lobby ruling. Finally, I'll examine how all of this has affected the national debate over religious freedom recently, and why this is a turning point for discussion in the issue. Now, the definition of religious freedom has evolved over time. Philosopher John Locke, whose opinions were instrumental in crafting many aspects of American democracy, argued that no one should be detrimentally affected by virtue of their religious beliefs and practices. After the atrocities of World War II, the newly established United Nations drafted a UN Declaration of Human Rights, adopted in 1948, which formally established religious freedom as part of international law. However, they did not cover beliefs of a non-religious character, and political, economic, social, or cultural beliefs were entitled to protection under the law, but the charter stated that they didn't belong in the religious sphere. In the US, the argument was first significantly challenged, that argument, in U.S. v. Seeger, a Supreme Court case from 1965. Daniel Andrew Seeger, among others, was a conscientious objector to the Vietnam War. His status as such was challenged because he didn't believe in a higher power. But the Supreme Court ruled in favor of Seeger anyway because his beliefs were parallel to the God-fearing individuals who were already covered, and therefore the exemption applied to him as well. 1 year later, the UN adopted this stance in a wider context by establishing the Human Rights Commission's International Covenant on Civil and Political Rights, which protected in Article 18 theistic, non-theistic, and atheistic beliefs, as well as the right not to profess any religion or belief. Article 18 goes on to state that the committee therefore views with concern any tendency to discriminate against any religious belief for any reason, including the fact that those beliefs are newly established or they represent minorities that may be the subject of hostility by a particular religious community. Both Seeger and the UN broadened the idea of religious protection to cover those not supported by popular religious or political opinion, and it is in this light that we consider the RFRA itself and how it came about. The spark that lit the RFRA's fire and led to a decade-long chess match with Congress over the religious freedom issue was a much more recent Supreme Court decision, Employment Division v. Smith, decided in 1990. There, the court decided that two members of the Native American Church could be denied unemployment insurance because they were fired for smoking peyote. The court declared that although the states had the power to accommodate otherwise illegal actions done in pursuit of religious beliefs, they didn't have to do so. And Justice Scalia argued that if they did, it would open the prospect of constitutionally required religious objections from civil obligations of almost every conceivable kind. In other words, opening up the option for religious people to sue for protection every single time they viewed an established law to be unfair to their personal religious beliefs or practices. Does that sound familiar? Now, Congress didn't like that ruling very much, so they passed the RFRA 3 years later to create a new standard. This standard argued that laws neutral toward religion may burden religious exercise as surely as laws intended to interfere with religious exercise, and to prevent that, the new law required a burden of any law on religious beliefs to be substantial, and any exception to that requirement would have to be at the least restrictive means of furthering a compelling government interest. So the definitions of a few of those terms are still controversial, but essentially this required laws to not negatively impact religious beliefs unless they were the only way to accomplish something the government had a very good reason to need to accomplish, and they did so in a way that had the least possible impact. In June 1993, after the legislation had passed the House of Representatives and had gone on to the Senate, the Supreme Court was faced with a very similar case to employment division. A church that practiced Santeria, a religion of Caribbean origin that practiced animal sacrifice, sued the city of Hialeah, Florida, for protection against an ordinance forbidding the unnecessary killing of an animal in a ritual not for the primary purpose of food consumption. In other words, an ordinance forbidding animal sacrifice. Now, the court perhaps saw that the tide was turning against its previous decision, and they ruled in favor of the church, saying that the city had no compelling interest to regulate its behavior, no matter how strange and incomprehensible it might seem to them. Now, the first Supreme Court case to specifically deal with the RFRA was City of Bourne v. Flores, 1997 case in which a Catholic archbishop tried to use it to argue that the Texas city's zoning laws shouldn't prevent him from enlarging his church. The court ruled that while the RFRA applied to the federal government, it didn't extend to the states. Now, this is kind of a complex idea known as substantive due process, but basically, under the Ninth Amendment of the Constitution, any rights not specifically declared by the Constitution or defined by the Supreme Court are left to the states to decide for themselves. And since the ability to not have your religion burdened by existing law wasn't a right granted to the Constitution, granted by the Constitution, or defined by the Supreme Court, the court ruled that it could not be imposed on Texas by Congress. 3 years later, Congress responded by passing the Religious Land Use and Institutionalized Persons Act of 2000. This act changed the definition of religious exercise to be no longer based around the First Amendment. Instead, it included any exercise of religion, whether or not compelled by or central to a system of religious belief. This not only addressed the zoning concern of Flores, but it allowed for any personal viewpoints attributed to religious belief to be protected under the law. Now, with this protection of religious freedoms established in this new way, the stage was set for last year's game changing Hobby Lobby decision. That case centered around two family owned for profit corporations. You probably know one, craft store Hobby Lobby, which the case is named after, and home furnishing manufacturer Conestoga Wood Specialties. These companies sued the Department of Health and Human Services over an Obamacare provision requiring the companies to provide contraception as part of their employee health care packages. The companies objected to two specific contraceptives, Plan B, the morning after pill, and intrauterine devices, or IUDs, both devices that disrupt or terminate early stage pregnancies, arguing that providing access to these devices through their healthcare programs violated their religious beliefs. Now, Samuel Alito's opinion on the case sided with the companies, stating that while providing contraceptive care to women was a compelling government interest, there were ways of doing so that would require companies centered around strong religious beliefs to do so. The federal government had already provided exemptions for religious organizations and churches and by providing contraception to employees through the insurance providers themselves. And the court ruled that the government could do the same in this case. Now, they specifically rejected the government's argument that the companies rejected their right to claim under the RFRA when they became for profit, stating that Congress didn't discriminate in this way when they wrote the legislation. Now, despite Alito's assertion that this was a very narrowly tailored decision that would have very little effect on most people, RFRA claims from companies and individuals came flowing in after the ruling, especially in light of the decision that made marriage equality the law of the land 1 year later. Now let's first look at the corporate claims, like those of Memory's Pizza. Vermont Law School professor Jennifer S. Taub argued in the journal Constitutional Commentary earlier this year that Alito seemed to depend on three conditions in determining Hobby Lobby and Conestoga to be exempt. Both companies had human owners that coexisted with the company since their creation. All owners of both companies shared the same sincerely held religious beliefs, and all of the owners of both companies ran those companies according to those beliefs. Now, this rubric, used as a test for future cases, would prevent most companies, even those determined to be closely held, as Hobby Lobby and Conestoga were, from being eligible for religious freedom exemptions. And that might be why Alito believed the case to be narrowly tailored. But in the same issue, University of Miami School of Law professor Caroline Mala Corbin refutes that argument, stating three reasons why for-profit companies lack the inherent characteristics that justify religious exemptions for individuals in the first place. First of all, for-profit companies don't have a personal relationship with God or any sense of dignity inherent to themselves. Unlike churches, they're not sacred, primarily religious, or a source of theological truth, and their employees aren't volunteers, and they have significantly more power over the political sphere than individuals do, especially in light of the recent Citizens United Supreme Court decision made in 2010 that granted companies the ability to contribute unlimited amounts of money to political campaigns through political action committees, or PACs. The reason RFRA was created in the first place, Corbin argues, was to protect individuals and churches, not companies, from laws created against their interests. And you may remember that there were no corporations in the history that I gave you prior to Hobby Lobby's claim. So with that history in mind, let's examine the individual argument, exemplified by Kim Davis. Now, this claim may seem less controversial in light of the many religious freedom examples for individuals that I've already given you. But Yale law professor Reva B. Siegel and UCLA law professor Douglas Najim say that it too is unprecedented. Unlike those previous examples, they call these most recent ones complicity-based conscience claims, meaning that these claims seek exemptions on the grounds that the laws in question make the objectors complicit in another person's sinful conduct. Because those claims focus on other people's behavior, they have the potential to damage the rights of those viewed as sinners by claimants. Accommodating religious freedom under those circumstances has very serious effects on the whole political sphere surrounding these sins, creating an us versus them situation in regards to rights and tending to extend legal conflicts rather than solve them. This is precisely why, even if Alito had the intention of issuing a narrowly tailored decision, he didn't succeed in doing so, because in solving the Obamacare contraception case, the court unintentionally tapped into the strong feelings religious people have toward homosexuality and same-sex marriage, and provided them the potential means of ignoring the laws set up to support them. Ironically, by siding with Alito in Hobby Lobby, Scalia brought about precisely what he said he didn't want 24 years earlier in Employment Division. legal chaos, as individuals and companies alike influence legislatures and contend with the courts in this brave new world of complicity based religious freedom law. As of September, 21 states have their own RFRAs, and 17 more are looking to create religious freedom legislation right now, according to the National Conference of State Legislators. This is an unprecedented interest boost just over the last year, and it's precisely due to the attention Mrs. Davis, Memories Pizza, and others have gotten defending their religious beliefs against legislation and case law that aims to protect others. Now, some would argue this to be a significant departure from the days when the laws being fought were purely discriminatory and the states were the primary opposition. But others would remind us that they still feel discriminated against, even after all that's happened. And in conclusion, there's just one more case I have to share with you, and perhaps you'll have an idea of where you stand on the issue after this. Bob Jones University, a conservative Christian college from my hometown of Greenville, South Carolina, sued the IRS in 1970 for threatening to revoke its tax exempt status. Now, at this point, Bob Jones refused to admit black students. They revised that policy in 1971 while the case was still pending to allow black students who were married, and revised it again in 1975, again while the case was still pending, to allow all black students except those who were married interracially. Now, the justification for all of these was its deeply held biblical principles. And in 1983, after a long series of decisions and appeals on those decisions, the Supreme Court finally found in favor of the IRS, stating that the First Amendment's religious protection does not prevent the government from taking action in favor of its compelling interest to eliminate racial discrimination. Now, depending on your attitude toward everything I've already told you about contemporary usage of the RFRA, you might see this outcome either one of two ways. Religious founders of a Christian university had their deeply held beliefs against educating black people or unmarried black people or race mixing, or all of the above, violated by the big bad federal government. Or the federal government brought equality to black students by forcefully upholding the law of the land, regardless of a few individuals' religious bigotry. At the very least, hopefully your opinion on this issue has been influenced by looking at our current situation from this perspective. Thank you very much.